Hello everyone, my name is SINI and I'm currently an intern in LEXIS and Company. The topic which I'm going to cover in today's video is search warrant under CrPC. The various law dictionaries and observed in different judicial decisions, the term search in a very simple language denotes an action of the government machinery to go, look through or examine carefully a place, area or object in order to find something concealed or for the purpose of getting evidence of the crime. The search of a person or vehicle or the premises can be only carried out through proper valid authority of law. It is also observed that there should be a nexus with the crime. It cannot be a random search. What is the search warrant? Search warrant is a written authority given to the police officer or any other authority by the magistrate or court for conducting the search of a place, either generally or specified item or document, or for the person who has been wrongfully detained. The court have time and again cautioned the power to issue search warrant shall be exercised with all due care. The court in Kalinga Tube versus D. Suri have and in many other cases have cautioned the police officer to use search warrant with little precaution and care and not to abuse their power. Section 165 of CrPC provides for the circumstances and in way which the search is carried out by the police officer. A police officer, while making an investigation, should have reasonable ground for believing that something very necessary for the purpose of investigation into an offence which he is authorized to investigate may be found in any place within the local limits of the police station in which he is in charge. He is also required to make a record in writing specifying the ground for believing and why the search was conducted within the limits of the police station. Now let us understand the circumstances under which the search warrant may be issued. The code enumerates the circumstances under which the search warrant could be issued. They are: first, where the court has reason to believe that the person to whom a summons or order of requisition has been addressed will not produce such a document or thing. Second is where such document is not known to the court to be in the possession of any person. Now let us understand the constitutional validity of search warrant. The entire procedure specified in the Code of Criminal Procedure 1973 is based on the principle of justice and fairness. One of the basic principles of legal jurisprudence is that the person accused of any offense should be given an equal chance to be heard and defend himself. It is compatible with the theory that there is a provision in the code itself related to the issue of process provision in section 161 clause 3 and section 162 of the code that any statement recorded during the course of investigation shall not be signed by the person making the statement has been specified. Similarly, upholding a similar provision, the protection under self-incrimination has been provided as a special fundamental right under Part 3 of the Indian Constitution. It provides that no person who is an accused of an offence can be compelled to be a witness against himself. In several cases, the constitutional validity of search warrant has been questioned. For instance, in the case of V.S. Kuttanpilla versus Ramakrishnan, wherein it was pointed out by the court that the search of a premises occupied by the accused does not amount to compulsion on him to give evidence against himself and hence was not violative of Article 20, Clause 3 of the Constitution. Now let us see what are the remedies against search warrant. First, instituting a writ petition under Article 226 of the Constitution for squashing an illegal search warrant and for return of the seized document or thing. Second is, an order under Section 93 can be set aside under 401 of CrPC in revision if it can be shown that the magistrate had not applied its mind judicially. There a search warrant carried out in the contravention of law constitutes a actionable trespass or suit of damage can also be filed against the person executing illegal warrant. So, from the above said things, we could conclude that the authority to search is an essential power for the betterment of the society. Search is an extremely subjective mechanism by nature, and specified procedure limitation has been placed on the exercise of the power. The officer empowered to perform a search have specified powers, and reporting to senior officers responsible is required at each level so that no officer acts in an arbitrary manner. The authority to search must be specifically prescribed in the law, and the officer in question must act in compliance with the specified rules and procedure laid down. Police officers are required with the authority to conduct inquiry, arrest the person, conduct search, seizures or the person and their property, and even use appropriate force in line of duty. Yet, this power must be executed within the limits of the law, and when officers exceed the limit, they jeopardize the admissibility of any information gathered for the prosecution. So I hope that this video helped you to understand what exactly is search warrant. Thank you.